Hey there guys, most judicial review questions are problem type scenarios, so that'll be the main focus of this lecture. But hopefully we'll cover enough stuff so that if you do get an essay question, you'll also be able to answer that. I think judicial review is sort of split into two main sections. Firstly, bringing a case for judicial review, and then secondly, the actual grounds for judicial review. So we'll cover both in this lecture. Right, let's get started.
So a question on judicial review normally centres around a person who has had a decision go against them in some way, and they'll be looking to challenge that decision through the courts by way of judicial review. Now, before we even get to that stage, we have to make sure that the person is able to bring a case, and there are four things that we have to look at in this first main section that I talked about in the introduction. So we'll go through each of these in turn. So the first point is that it has to be brought in relation to secondary legislation, and the important thing is here that primary legislation or acts of parliament cannot be challenged, and this comes back to the constitutional idea of parliamentary sovereignty. Parliament should be able to make any laws that it wants to, and those acts of Parliament cannot be challenged in the courts. Instead, we're going to be looking at the challenging of secondary legislation, so statutory instruments, in particular regulations, orders, and most commonly in scenario type questions, decisions of public bodies. So that brings us on to our next point. What is a public body? Well, there's a couple of key cases here. In Ex parte Aga Khan tried to bring a case against the Jockey Club, and the courts turned around and said, well, actually, the Jockey Club is a relationship between private individuals operating out of the public sphere. And so Aga Khan was not able to bring a case for judicial review. The court said that instead, those types of decisions should be challenged through private law rather than public law. It doesn't necessarily bring us closer to a definition for a public body, though, but Datafin is a really good case and definitely one to use in any question on judicial review because it provides us with a broad definition for what a public body is. Now, in a lot of cases, this might be obvious because it'll be a council or a school or some obvious part of the public sector. But Datafin looks more closely at the functions that a body is performing. So if the functions of a body are mainly public in nature, then it can be considered a public body. If they're mainly private in nature, then it isn't, and those decisions by that body, as in Aga Khan, cannot be challenged. So when you're analysing this in a problem question or within an essay, do make sure that you sort of consider those types of factors. What function is the body actually performing? Locus standi comes down to the idea of standing. Do you have the standing to bring a case? And the main question here that the court asks is, does the person have a sufficient interest in the case? And there's a really good quote there from Lord Scarman in the Fleet Street Casuals case. And they said that it's important that we don't have a judicial review system that basically allows any random person off the street to challenge any decision that they just don't really like for whatever reason. So the person has to have an actual interest in the case. The decision or the regulation has to affect them in some way. Now, the courts have expanded this out a little bit, and we see that with the Greenpeace case at the bottom of the screen. In this case, Greenpeace, who are obviously a widely respected environmental pressure group, tried to bring a case, and the Inspectorate of Pollution said, well, they shouldn't be allowed to because they're not local residents. They're not actually directly affected by the pollution in a particular area because they're a global pressure group, so they're not directly affected. And the court said, well, actually Greenpeace, because of their availability of funds, because of the research that they've carried out in this area, they're in a much better position than the local residents to bring a case. And so the courts in this case did allow Greenpeace to bring a case for judicial review. So that slightly expanded definition is definitely one to bear in mind when considering locus standi and the sufficient interest test. Now, the time limit's very simple. It's taken from the civil procedure rules, in particular Rule 54.5 says that a case must not be brought later than 3 months after the grounds to make the claim first arose. So as we said, it normally involves a decision going against a person, and that decision being made starts the clock, and therefore a case has to be brought within 3 months of that decision being made. Now, there's a few minor exceptions that you could look into if you wanted to, but to be honest, the courts do tend to strictly apply this rule, just to prevent any sort of miscarriages of justice or a case being delayed for such a long period of time. So generally in a problem question, do apply that as a 3-month strict rule that is applied by the courts. Now, before we move on to the grounds of judicial review, do you want to talk quickly about Alstead clauses, and these are basically attempts to exclude judicial review. So in the most famous case of Anisminich and FCC, the law in question said that decisions shall not be called into question in any court of law. And the important thing here was that the court said, well, we're not really challenging the final decision as such. What the point of judicial review is to look at the grounds for that decision in the first place and the way that decision came about, not really looking at the final decision as such. And so they got round the ouster clause in that particular case. In theory, an ouster clause could work, but it would have to be worded very specifically to get rid of judicial review. Basically, the courts don't like ouster clauses because judicial review is a really important part of public law. It allows members of the public to challenge decisions that do fall under one of the 3 grounds that we'll look at next. So the 3 grounds for review are irrationality, illegality, and procedural impropriety. So we'll go through each of those in turn. The first of them is irrationality, and law students tend to fall into a bit of a trap here because they think, oh, well, that decision doesn't seem very sensible, therefore I think it can be challenged on grounds of irrationality. But irrationality actually is a much more stricter test than not a decision not being very sensible. And we can see that through Lord Green's quote in the famous Wednesbury case from 1948. A decision has to be so unreasonable that no reasonable authority could ever have come to it. And we move on in the GCHQ case. Lord Diplock says that it has to basically be completely outrageous in its defiance of logic. So you can see here that irrationality, rather than it being a sort of catch-all test that will take out any decision that is a little bit kooky or a little bit strange, it has to be basically completely off the walls. So in the Wednesbury case, the council famously was given the power to restrict cinema access on a Sunday, and the council said, oh, well, that means that we can prevent 15-year-olds going to the cinema. And the courts turned around and said, what the hell are you talking about? The rule had absolutely nothing to do with age limits or 15-year-olds. It was to do with Sunday opening times. And so you can see there that the decision was just so completely batshit crazy, for want of a better word, that the courts were able to challenge it on grounds of irrationality. So I've split these main cases up into levels of reviewability, if you like. So at the top we have non-justiciable issues such as the GCHQ case. This involved the government secret services, and the courts didn't really want to get involved in security matters, and so that wasn't reviewable. In a sort of similar way, policy areas are also non-reviewable, even though a government minister's decision might seem not very sensible to some people on the political spectrum. It's not an area for the courts to get involved with. They're not involved with politics. They should be removed from that discussion. So you could maybe think of something like the recent decision by Jeremy Hunt involving contracts for junior doctors. And some people would say that that is an irrational decision, but really it comes down to politics. So it's the policy of the Conservative government to enforce that contract on junior doctors, and so the courts would not get involved with challenging that decision generally. In the middle, we have the reasonable test that we've already talked about from Wednesbury, and moving towards more reviewable cases or areas where a judicial review is more likely to succeed. We have areas of human rights. So Ex parte Smith from 1995 involved homosexuals in the army, and that case actually wasn't successful. You'll notice it was before the Human Rights Act came in. But then in Daly, which is the 2001 case, they went to the European Court of Human Rights, challenged the decision against homosexuals in the army, was successful in Europe, and therefore were able to bring a case for judicial review. And we'll look at human rights a little bit later on, and we'll see how that offers a more generous way to approach judicial review and makes reviews more likely to succeed. That idea of proportionality as well is something that's also taken from European Union case law, and it's a bit more of a fair way of taking a balance when you're looking at a decision. So looking at the rational aspects and the irrational aspects of it, and weighing the decision up overall. Illegality is possibly also another misnomer and another area where law students tend to fall down, because a decision isn't really illegal. It's more ultra vires, which literally translates as outside of the power. So it involves a minister or a public body of some sort acting outside of their allocated powers. And we see that in the early case of Attorney General and Fulham Corporation from 1921. The rule in this case allowed local bodies to set up laundrettes for the poor so that they could do their washing for free. And instead, the Fulham Corporation in this case set up a commercial laundry where they charged members of the public. And they said, well, this isn't really the point of the law. You weren't given the power to open a commercial laundry, and so you have acted outside of your powers in this particular case. Illegality can also take into account irrelevant considerations. So in Port Talbot Borough Council ex parte Jones, the local council prioritised giving a council house to a local councillor on the basis that she needed it because she was the councillor for that area and therefore she ought to live in that area. But this didn't really take into account the considerations that the council would normally apply, such as the need for a council house. Are there children involved? Things like that. So the fact that Jones or whoever it was, the local councillor, was a member of the local council was completely irrelevant when coming to the decision. And so irrelevant considerations do also play a part in whether a decision is ultra vires. Unauthorised delegation of powers as well is relevant. So National Dock Labour Board, what happened was that the National Dock Labour Board were given the power to set up a disciplinary committee, and they delegated that power to each individual local dock. And they basically said, well, you were given the power to set up a disciplinary board, you weren't given the power to delegate that particular power even further down the chain. And so unauthorised delegation of powers can also come under ultra vires illegality. Finally, we have procedural impropriety. This is a lot more simple and just means that the correct procedure wasn't followed. So in Aylesbury Mushrooms case, the relevant department failed to consult the Mushroom Growers Association, and so they said that you haven't actually fulfilled the correct procedure for taking a decision, and therefore the decision doesn't affect the Aylesbury Mushrooms Growers Association, and that can be challenged on judicial review grounds. Procedural impropriety is also sort of broadened out a little bit, so it includes bias as well, and we have the test there from Lord Lane. Would a person conclude that there was a real possibility that the tribunal was biased? So again, we don't have to prove that there was actually bias in the case. We just have to deal with the suggestion that there might have been bias. It comes back to the famous quote from the Sussex Justices case that justice must not only be done, it must also be seen to be done as well. And so that's important to remember. Fair hearing, another old case for this, Cooper and Wandsworth Board of Works, and this sets up that there should be a fair hearing whenever any sort of decision is made, and this might include things like the right to an appeal, the right for both sides to be heard, the right for someone to present their own arguments. This might not apply in all of the cases, but generally speaking, a person should be allowed to make representations when a decision is actually affecting them. moving on in procedural impropriety, we also have legitimate expectations as well. So in the Liverpool taxi case, the Liverpool Taxi Association were given assurances by Liverpool Corporation that a decision would not be taken without consulting the taxi drivers first, and then Liverpool Corporation made the decision anyway. And they said, well, this wasn't really fair because the Liverpool taxi drivers should have been consulted because they had been given assurances and it had raised a legitimate expectation that the drivers would be consulted before a decision was actually made. And generally also a reason should be given for a decision. So we have ex parte duty for that particular ground. So generally speaking, reasons should be given for any particular decision. The Institute of Dental Surgery are put in there because if the decision is very straightforward and really just academic in nature, so a foregone conclusion, then in that particular case it might not always be necessary for reasons to be given. But I definitely think that this is something worth considering in a problem question. If reasons aren't given for a decision, that's not really very fair. And to go back a slide, it comes back to that idea for a fair hearing as well. When you have a fair hearing, you should also have reasons given for a particular decision at the end of that fair hearing. So before we come to the end of this and move on to remedies, I want to talk a little bit about human rights because I think this is maybe an area that you could gain some extra marks on in an exam question or in a coursework. It's something that students tend to forget about because it is still a relatively new phenomenon within the area of judicial review. And a key section of the Human Rights Act 1998 here is section 6.1 that says it's unlawful for a public authority to act in a way which is incompatible with a convention right. And so it's something to bear in mind, especially thinking back to procedural impropriety. We can think about the right to a fair hearing, and that links very closely to Article 6 of the European Convention on Human Rights. And so if you don't think that there's been a fair hearing or reasons haven't been given for a decision, then definitely mention Article 6 because it is an important consideration. And as we can see from section 6.1, it's something that the courts ought to take into consideration, that public bodies should be taking into account people's convention rights. Obviously, it can also extend beyond Article 6, so we can maybe think about Article 10 as well. So when you're you should be given freedom of expression, your right to present a case before a decision is made. Also, things like Article 8 might even come up as well. So if a decision is made to kick someone out of their home, that comes back to the right to family life and private life, and the right to, have some sort of secure private individual space that can't be invaded by a local council, for example. So lots of things that you might want to consider, and definitely keep that human rights knowledge at the back of your brain when answering any question on judicial review. So very finally, we'll look at remedies, and I've listed all of the remedies there. Most of them are relatively straightforward. Students often forget to put this in at the end of a judicial review question, but if you think that a person is likely to succeed for judicial review, you've got to think about, well, what does that person want? Do they want the decision to be quashed? So it's completely sort of taken out. Now is probably an obvious one, but other orders might be appropriate in different circumstances. So a prohibiting order, prohibiting a public authority from doing something, say cutting down a section of forest or wildlife. A mandatory order, so making a public body do something. A declaration as to the situation that the legal parties are in, just to avoid any future confusion. Injunctions are also important when going through a case. So before a final decision is made, that can sometimes take years, should an injunction be granted to prevent the public authority doing something within that time? So an interim injunction, so an injunction against a public body until the final decision is actually taken, or a permanent injunction to permanently stop a public body from doing something. And they can be both positive and negative, so forcing a public body to do something for a positive injunction, or stopping a public body from doing something for a negative injunction. And every law student's favourite remedy that they always put into questions and answers is damages. So if a person's been negatively affected by a decision in an economic fashion, is there an argument that they should possibly also receive damages? Now, don't focus too much on damages, because obviously the point of judicial review is to get a decision overturned in some sort of way with one of the remedies above. But if there has been an economic consequence, then definitely also consider damages as part of your answer. When structuring your answer in a judicial review question, do make sure in the first section to cover all 4 of the reasons on the basis that a person can bring a case. So does it concern secondary legislation? Is it against a public body? Does the applicant have locus standi? And are they bringing the case within the 3-month time limit? When you move on to the second section, do have a careful think about it. Not all questions will involve all 3 grounds for judicial review. So some might only concern procedural impropriety, some might concern illegality and irrationality. So it's really important that you do have a careful think and don't just go for a blanket response that covers all 3 grounds. Thank you very much for watching. If you enjoyed the video, then do leave a like, subscribe for more videos, and if you do have any questions or comments, then leave them below. A lot of people have got in touch requesting other videos on a number of topics, so I'll try and get round to those when I can. If you have suggestions for other videos that you'd like me to cover in a lecture, then do comment below and I'll try and get to them whenever I can. Thanks very much for watching. Bye!